Hello, my name is Mark Witter. I'm the Chief Operations Officer for Anglo Research Services. Anglo Research Services has been providing professional genealogy services to the legal profession and trust companies for the last 30 years. We're specialists in locating and tracing lost heirs, missing beneficiaries, unknown next of kin, absent legatees and unclaimed assets.
Hello, my name is Martyn Frost. I'm a Director of Trendfield Trust and Estate Consulting Limited. The subject I'd like to comment on this morning is the old chestnut for private client practitioners, that is the golden rule, Templeman's famous formulation of the necessity to involve a medical practitioner when preparing wills for the elderly. The golden rule has long been a feature of judicial consideration of the conduct of the will draftsman when preparing a will for the elderly. But recently we've seen that the golden rule can be quite a substantial problem for the private client practitioner. The problem comes in connection with the time taken to prepare a will. We know on the one hand that the golden rule encourages us to involve a medical practitioner in order for the medical practitioner to give us an assessment of the client's testamentary capacity. But on the other hand, since the mid-90s, we have also had White and Jones, the House of Lords' views on the speed with which a will should be prepared for an elderly person. It is in practice quite difficult to put these two subjects alongside, because the speed with which a medical practitioner is prepared to become involved may actually be too slow for us to consider the time that the courts require us the time limits the court require us to act within in order to get the will prepared for an elderly person. In other words, in practice, you're looking at trying to prepare a will for an elderly person in a very short period of time, but on the other hand, their medical practitioner may be saying, I can't perform any assessment of the client within the next 4 weeks. The draftsman therefore is faced with a bit of a dilemma. Should he proceed with the will? Should he not proceed with the will? If he delays, does he run a risk of a White and Jones claim for negligence? And it makes the practitioner these days fairly uncomfortable. The discomfort is increased by the willingness of courts to use non-compliance with the golden rule as a stick to beat the practitioner with. Last year we saw the decision in Key where the judge castigated a solicitor for not paying any attention to the golden rule and preparing a will which was subsequently found to be invalid for want of testamentary capacity. Key is a fairly awful warning that we do need to pay attention to the golden rule, but on the other hand, sometimes we can't arrange for the medical practitioner. So how should we proceed? Other decisions have shown us quite clearly that if the private client practitioner is able to record properly in a good full attendance note what transpired at the meeting, particularly recording the reasons why he concludes the client could proceed with a will, had sufficient capacity to do that. We have had circumstances where the courts have said that is the correct thing to do. The case of Scammell and Farmer, for example, where the judge praised the experienced practitioner for giving good, clear evidence. Evidence, by the way, that the court found highly persuasive and disregarded the medical evidence against testamentary capacity. So the interrelation of White and Jones with the golden rule actually takes us back to placing much greater onus on the private client solicitor to consider what is going on in the interview when he sees the elderly person, and indeed how he records it and how he reaches his conclusions. And I think if under those circumstances the conclusion is reached that whilst the testator may suffer from a degree of impairment, if the practitioner is satisfied that that is not sufficient to deprive in the testamentary capacity, then I think to proceed with the will is quite proper. And I don't think that the will draftsman under those circumstances has got any great costs risk if subsequently the will is found to be invalid. I think if the draftsman's behaviour falls significantly short of that which we would expect from a professional, then there could well be a risk. And indeed there have been one or two judicial indicators that they would be at risk of having part of the cost of the action regarding the validity of the will being placed on the draftsman. It does mean that one of the things we should be doing with the elderly client is trying in advance to determine what our policy is and how we will deal with the elderly. Firms these days are required to have a risk management policy, and in my view, having a risk management policy carefully thought out and described for the benefit of all people within a firm who are dealing with wills is a great way to approach risk management. It stops more junior members of staff or less experienced members of staff being forced into difficult decision making when they encounter these problems for the first time. If ahead of that a firm has determined the manner in which they wish to deal with the golden rule issue, with the White and Jones urgency, with questions of capacity, recording in good attendance notes, this will help all members of a firm to arrive at more safe conduct that does not expose the firm to costs and delivers a better service to the clients. Thank you.